Sure, abuti ornashi.
Citizen, from information gathered through the collateral sources, family members that he interviewed, as well as the victim impact statement presented yesterday by your mother, is portrayed as a person that's manipulative and manipulate the facts as it suits you. Went as far as to blame your parents for your conduct in this matter. The evidence presented as to the disappearance of your own daughter was clear. Besides, on one occasion earlier and yesterday, I saw no indication of remorse. But it didn't start there, because we know from the 19th of February 2024, the lack of concern. Yes, I have to take into account that you have 2 other minor children, but fortunately they are being cared for currently. So the caution that I have to take when imposing a term of imprisonment on a mother and a caregiver, as was expressed by the case of M in the Constitutional Court, bears less weight. Mr. Peterson have, however, also indicated that steps should be, and we heard in the main trial that steps have been taken to ensure for the care of the 2 minor children. I gather from the evidence of Mr. Peterson and the victim impact statement from your mother that you were given all the opportunities. Yes, you were born under difficult circumstances, but you were given the opportunity through your grandparents that cared for you to have a stable life. You, unlike Mr. Apollos and Mr. Van Rijn, that did not fare that well at school, you matriculated. In the victim impact statement from your mother, it was clear that they wanted to assist you even after the onset of the drug use and abuse. You, in a threatening way, pushed that helping hand away. Up till now, I've not seen remorse. So in the personal circumstances alone, I do not find any mitigating circumstances. Now the prosecutor will argue, and have argued, that having found that, the law is clear if there's a prescribed sentence and there's no substantial circumstances, as I've indicated, that is compelling, that must be the end of the inquiry on the face of it. It's not that simple, because sentence still remains the discretion of the court, and the approach must be that you cannot only focus on the one element. Everything has to be determined holistically, and a balance must be struck. I'm going to start with reference to the prescribed sentences. By indicating that the inquiry must be that the prescribed sentence must be fair and just. If not, the court would be moved to impose a lesser sentence. So I do not deem the prescribed minimum sentence as the only guiding factor in determining the sentence. Let me turn to the next issue, which is the offense. I don't need to stress the seriousness thereof. On count 2, you were convicted of kidnapping. Kidnapping of a 6-year-old child, having the effect of depriving her of her freedom of movement and her liberty. Yes, often one would look at whether there was violence involved or the circumstances that would have harsh effects on the victim. It was argued on behalf of the defense that there's no evidence before the court that Joshlin suffered any harm. There's no merit in such an argument. It must follow by depriving somebody of their liberty and their freedom of movement. It cannot go without at least emotional harm. This brings me to count number 1. The purpose of the act is particularly aimed at the exploitation of a human being for all sorts of purposes. In the particular case, Mr. Apollos and Miss Smith were in a parental relationship with Joshlin. I want to remind you of the facts of this offense. Ms. Smith indicated in August 2023 to Mr. Kutsia that she was unhappy in her home. She wanted to get rid of her child so that you and Mr. Apollos could have a better life. How callous is that? I'm reminding you, I'm speaking of the offense. Then there was the interventions which I cannot ignore during the period, Miss Smith, that you had to go to the rehabilitation center on 2 occasions. First one was when Joshlin was a baby. Andrew's family took care of her. And I'm fast forwarding to the victim impact statements that we had. And I will return to it again and remind you constantly of it. On the day before, the 19th, being the 18th of February, the discussions took place after an incident that had upset you. And that was the alleged charge of the chicken theft that somebody dared, in your view, to lay against Mr. Apollos. Because you expressed the views that you're going to expose the complainant for daring to name him as a suspect. That led to a heated argument between yourself and Mr. Apollos. Eventually, Joshlin being dragged towards the house. An independent witness came to tell us that. That conduct seems not to have been an isolated incident, because I remind you of the evidence of Mr. Peterson, of what the collateral sources had told him. And this went unchallenged, of your actions towards her. That's when the discussion took place. According to Mr. Apollos, the motivating factor was you again putting the blame on others for treating your child as a commodity and selling her off. Miss Lombard and Mr. Van Ryn went along. Both of them parents of small children. Mr. Van Ryn, your daughter would have been 3 years old or younger if she's 4 now. Then the plan are being put in place. I pause to remind you, I'm talking about the offense. Next day, for 20,000 rand, Joshlin is sold. Nobody knows where she is. The victim in this type of offense and the treatment of the victim is important. Dr. van der Walt reminded us of some of the factors that the Act says I must take into account. And I said at the outset, I'm not necessarily going to tabulate them, because I want you to understand the seriousness of the offense. Mr. Apollos tells us that on the morning of the 19th, he fed Joshlin. He cared for her, he says, looks her in the eye and sells her. And Mr. Apollos, then you sit there and you say nothing. This is the offense. Betraying the trust that she must have placed in you, Mr. Apollos, as a parent, although not her biological father, and you, Miss Smith, as the one that gave birth to her, and you, Mr. Van Ryn, being that good friend and the father of a small child. Turning back to the offense itself, and the effect it has on the community, we've heard, and I've heard, the victim impact statement of Ms. Olivier. Joshlin was a child in the community. We heard how she would go to some of the houses on the evidence presented here, including Ms. Olivier, and how she would sit at that table. Ms. Lombard, and I am going to deal with her situation in a different hearing, also looked Joshlin in the eye, gave her something to eat, and did nothing to protect her. The society and the community of Saldanha was torn apart. We heard about the extensive searches that took place, and a victim, because the broader community are victims, saying to me through the statement yesterday, I still cannot wear the clothes I wore when we searched. We're 15 months in. We heard in the evidence on the merits trial that people are still searching. We heard about people from all over that came, and the resources employed. But the community was fractured by the conduct of the three of you. Ms. Mart speaks on behalf of her children, she says. And sometimes she refers to them as her learners. In her evidence in the merits trial, she referred to the person who called her as one of my mothers, referring to a mother of a child in her class. We saw the tree. We saw the fingerprints of those young kids would now be in grade 2, and the missing one. We heard the evidence of how a community has become more concerned that her children or their children doesn't go missing. Ms. Mart tells us that it became more of the norm that parents would drop and fetch their children because they feel unsafe. That's the effect your crime has had on the community. Ms. Daniels, I apologize that I have to single you out, but I've heard you. When your son, Ms. Smith, goes to school or rugby practice, your mother doesn't know if he's just a wee bit late, how to deal with it. The extent that we fortunately saw people uniting and rallying in the defense of children. And if there's one positive that have come out of this case, is what I saw by having the fortunate opportunity to serve, in this case, in this place, of how disciplined a community can be and how united they can be in the defense of the dignity of the community. Now, because the community has an interest in the offense, they have certain demands and they have certain outcries. I'm sure there are many that would ask for a sentence that would be inhumane. That's why we did away with it. Because they don't see even a life imprisonment as enough punishment for the harm done to the community. But then I remind myself on what I read out to you earlier in this judgment. I spoke of the two aspects of the purpose of the sentence. And I spoke of how one should balance these factors. I tried to explain to you how your personal circumstances and the offense and the interest of society interacts in the determination of the sentence. And and how I caution myself of trying to be compassionate, to be humane, to show mercy, not to have anger, not to have the anger of the community affect me to the extent that I act not in the interest of the community, but rather adhere to the wishes of the community. I try to stay away from that. I've referred to the minimum sentences and the prescribed sentences. And yes, if I heed the request of the prosecution, I should impose life imprisonment. But let me think of the options in explaining to you. It's clear that a sentence of imprisonment is the only appropriate sentence. The question is just how long. You are all three relatively young. And yes, one of the purposes of a sentence is to rehabilitate the offender. And I'm well aware that there's always that potential. How do you balance the interest of society and your own prospects of rehabilitation when somebody commits such a heinous crime? I'm of the view that even if I was not bound by a prescribed sentence, I would still have considered the harshest sentence I could impose. Because to my mind, balancing all these factors and circumstances that I've indicated to you, it would indicate your moral blameworthiness. And saying that, I do not forget that at the time of the commission of the offenses, you were using and have been using substances that could have had an effect. But it's no excuse. Because if it was a factor that affected and led you to the commission of the offenses, you had the opportunity to tell me. But I didn't think straight at the time because I was under the influence. You simply didn't do that. In fact, it seemed through the course of this trial that you, Mr. Van Ryn, and Ms. Smith, you found it amusing. At one stage I indicated to you that when certain witnesses were testifying, I don't see the captain here today, you were celebrating. Didn't take it serious. There's nothing that I can find that is redeeming and deserving of a lesser sentence than the harshest I can impose. I'm well aware that The second charge was part of the whole planning. And I need to temper the effect of that sentence. Before I announce the sentences in this matter, the prosecutor requested me that I should order that your names be entered into the National Child Protection Register. In the circumstances of this case, it is an order I'm going to make. Lastly, I indicated in the merits trial my disappointment as to the proper compliance with the Poker Tip Act by the administrative systems to be put in place. I would urge the government role players to ensure that it is done rather sooner than later, because it is aimed at protecting the vulnerable and achieving the objectives of the Act. I cannot make an order because I don't have sufficient detail. Mr. Van Ryn has already been declared unfit to possess a firearm. In considering that result for Mr. Smith and Ms. Apollos, I need not make an order because of the sentence I will impose. There's no prescribed sentence for the kidnapping charge because of the severity of the facts of the kidnapping as it relates to a minor child. I'm of the view that even for that charge, a long-term imprisonment should be imposed. So for the reasons that I've expressed, and I hope you understood, I'm going to impose the sentences now. May you stand. Mr. Apollos and Mr. Van Ryn and Ms. Smith, I'm going to announce the sentences at the same time because your sentences are the same. I'm not going to draw any distinction, even though Mr. Van Ryn has previous convictions and you, Mr. Apollos and Ms. Smith, does not have. On the human trafficking charge, you are sentenced to life imprisonment. On the kidnapping charge, you are sentenced to 10 years imprisonment. Because I've imposed life imprisonment, there is no need for me to rule on the concurrency of the sentences, because by operation of law, it will be served concurrently. Mr. Apollos, do you understand that? Mr. Van Ryn, do you understand? Ms. Smith, do you understand? Thank you. You may be seated. I'm also ordering for the entry of your names into the National Child Protection Register. The court will adjourn.
Sure, I would do honestly.